Dear students, hope you all are fine. In this video, we'll discuss about a very important chapter which you have to prepare for your CLAT examination and all other law entrance tests. Legal reasoning. Now, what is legal reasoning? When you have a particular problem to solve or you are finding solution to a particular situation which involves a problem with help of your logical thinking or logical power, it's called reasoning. When the power of reasoning is coupled with the knowledge of law, or you are trying to find out the solution of a problem in a legal way, it's called legal reasoning. To have a good score in legal reasoning, you should have a good conceptual idea in different segments of law. For example, the law of crime, law of torts, constitutional laws, and the law of contract. For the criminal law part, your idea should be very clear on the concept of crime, a few sections of Indian Penal Code, which is now Bharatiya Nyaya Sanhita, the concept of guilty intention or guilty mind, and the general exceptions. Dear students, now let us discuss some practical problems. A is a 5-year-old kid. One morning she enters into the kitchen when her mother was absent. Somehow she gets the kitchen knife and starts playing with it. B, another child from neighborhood visits their home at that time. A starts to play with B with the knife and while playing causes grievous hurt to B. Now what are the options? A is guilty of causing grievous hurt to B. B, A is guilty of attempt to murder. C, A is not guilty as her mother was absent. D, A is not guilty. The right answer is D. A is not guilty. But why? Look, A is a child who is only 5-year-old and she causes grievous hurt to B. Now students, to form a guilty intention or criminal mind, one has to come up to a certain age. At the age of 5, it is not possible to form such guilty intention. On the very basis, the right answer will be D, that is A is not guilty, because A has not come up to the age when she formed such a guilty intention to commit a crime. Let us come to the next. A makes an attempt to pick the pocket of Z by thrusting his hand into Z's pocket. Z has nothing in pocket. What are the options? A is guilty of theft. B, A is not guilty. C, A is guilty of attempt to commit theft. Students, here the right answer will be C, A is guilty of attempt to commit theft. Why? Because A already had the guilty intention to commit theft. He has done some act in furtherance of such intention, and because he has failed in his ultimate object, he is guilty of attempt to commit theft. Now come to the third example. Z, under influence of madness, attempts to kill A. A, for self-defense, picks up a knife and stabs Z. What are the options? Z is guilty because he attacked first. B, A is guilty because he stabbed Z. C, A is guilty because Z is mad. D, A is not guilty because he has right of self-defense. Students, here the right answer will be D, that is A is not guilty because he has right of self-defense. Here Z is also not guilty because a person of unsound mind cannot commit a crime. But A has the right of self-defense as much as and equally in a situation if Z were not mad. So under this ground, A is not guilty because he exercised the right of self-defense. So dear students, I guess you have already understood how important is the intention or the presence of criminal mind or guilty mind to constitute a crime. In our next session, we will discuss many more important things which you have to prepare for your law entrance examination. Thank you.